South Carolina adopted the Residential Landlord and Tenant Act back in 1986, and it's found in South Carolina Code Title 27, Chapter 40. This gives the state a solid statutory framework for habitability, but South Carolina still leans more landlord-friendly than many states on the East Coast. Under South Carolina law, landlords must comply with all applicable building and housing codes that materially affect health and safety. You're required to make all repairs and do whatever is necessary to keep the premises in a fit and habitable condition. Specifically, that means maintaining the structural integrity of the building, keeping plumbing in reasonable working order, providing running water and adequate hot water, ensuring electrical systems are safe, maintaining heating systems, and keeping common areas clean and safe. Now, here's something that makes South Carolina a bit different. The law allows landlords and tenants to agree in writing that the tenant will perform certain maintenance duties. This includes things like minor repairs, trash removal, and even some utility responsibilities. But there are limits. You cannot shift the responsibility for maintaining essential services like plumbing, heating, or structural soundness to the tenant. Those remain on the landlord no matter what the lease says. When a habitability issue arises, South Carolina requires the tenant to give the landlord written notice. The landlord then has 14 days to make the repair. If the landlord fails to act within that window, the tenant has options. They can pursue the issue in court and seek remedies including damages, and in some cases, lease termination. South Carolina does not have a statutory rent withholding remedy. Tenants can't simply stop paying rent because of a repair issue. They have to go through proper legal channels. This is an important distinction that actually provides landlords with some protection against tenants who might try to use habitability claims to avoid paying rent. The state does offer protection against retaliation. Landlords cannot increase rent, decrease services, or file for eviction in response to a tenant making a legitimate habitability complaint or contacting code enforcement. One practical tip for South Carolina landlords: document everything. Keep records of maintenance requests, repairs completed, and any written agreements about tenant responsibilities. If a dispute goes to court, your documentation is your best defense. For the full guide to South Carolina's habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for more state-by-state landlord guides.